Bashan on behalf of Mr. Michael Chalumba. He's present via Polycom from the Ingham County Jail.
Thank you. Mr. Chalumba, and Ms. Rensman is here. Go ahead, Ms. Rensman.
Haley Rensman, probation officer.
Thank you. And Mr. Chalumba, I see you. Are you able to hear and see the court and everyone else?
Yes, Your Honor.
Okay, thank you. So we have two orders to show cause. I know that there was some issues. Mr. Chalumba was ordered to appear for this on 2 days ago on March 25th. We adjourned this after information that Mr. Chalumba had turned himself in another jurisdiction and was likely going to be in custody, and that's where he is today. So unless anyone has anything further on that, I'm going to just proceed right to the orders to show cause. Ms. Sumner?
No issue with that.
And Ms. Bashan?
Sounds good, Your Honor.
Okay, so Mr. Chalumba, I want you to know it is alleged that you violated your bond as follows: that you failed to test at AverHealth as directed by your probation officer on March 9th, and that you no-showed for testing on March 12th as evidenced by an AverHealth no-show report. Additionally, it is alleged that you violated your bond in a supplemental violation by not appearing for testing on March 17th and March 18th as evidenced by AverHealth no-show reports. Mr. Chalumba, the maximum possible penalty for these bond violations is up to 93 days in jail, and that is separate and distinct from the underlying maximum possible penalty for your charge, and could be punished by up to $7,500. Do you understand these allegations and the maximum possible penalty?
Yes, I understand, Your Honor.
I want you to know, sir, that you have a right to an attorney to assist you. Ms. Vachon is here with you today, and you have a right to a hearing. Ms. Vachon, how are we proceeding?
Your Honor, he will admit to the violations.
Okay, Mr. Chalumba, please raise your right hand. Do you solemnly swear or affirm to tell the truth under penalty of perjury?
I swear.
Mr. Chalumba, is it true and accurate that you failed to test on AverHealth as directed by your probation officer on March 9th?
Yes, Your Honor.
And also on March 12th?
Yes, Your Honor.
And also on March 17th?
Yes, Your Honor.
And also on March 18th?
Yes, Your Honor.
Okay. And has anyone promised you anything to get you to admit responsibility to these violations today?
No, Your Honor.
Has anyone forced you to do this?
No, Your Honor.
Is it your own choice?
Yes, Your Honor.
I accept your admissions. And with that, I'll be happy to hear from everyone present. I just note that these violations, the first set, the court saw Mr. Chalumba on March 9th for another order to show cause, and there have been many violations of bond while Mr. Chalumba has been pending before this court. On March 9th, specifically, he was ordered to report to probation immediately for a pre-sentence date and a sentencing date, and it looks like that was when he was ordered to test, and he immediately failed to do so and then continued to fail to do so. I also note, given Mr. Chalumba's running of his criminal history and the circumstances that lead us here today, or lead him where he is today, that Mr. Chalumba has been charged with another crime and another jurisdiction in Lansing. And per my information, it looks like that's a felony involving a stolen motor vehicle. So with that, I guess I'll begin with you, Ms. Sumner, on behalf of the city. Anything you'd like the court to consider?
Yes, in addition to all of the things that you've already noted, in speaking with probation, we would like to recommend that he get a scram prior to any release. And we're also looking at a request for suspended time.
Okay. So you're asking for the court to impose a sanction for the bond conditions today, or, I mean, I also could just, he has bond violations. I can also revoke his bond and he could be held till sentencing.
I see probation nodding, and so I believe we're in agreement with that plan.
Okay. Ms. Rensman, on that, what would you like the court to consider?
helps if I unmute. I will note that Mr. Tish Limbaugh has only tested twice, and they were both positive for ETG, and that was back in November. I will give him credit. He did appear on Tuesday for the PSI with me. However, Officer Bragg is taking him on due to the complete incompliance. And Officer Bragg was not in the office, so we rescheduled him for the date of the original order to show cause. But we will be able to get with ICJ and schedule that. But yeah, I do give him credit for showing up that day. He does communicate sometimes. I'm not sure what his barriers are to testing or if it's just in compliance.
Okay, so I appreciate that information. Mr. Chilumba, as I said, was ordered to, he needs his pre-sentence investigation done, but through no fault of his own, that hasn't happened yet.
Correct.
Okay, I appreciate that. Thank you, Ms. Rensman. And Ms. Vachon, what would you like the court to know?
Yes, Your Honor, Mr. Chilumba certainly is not intentionally disregarding the court's orders. He has been in good communication with me, but he is just really struggling in his personal life. He's only 18 and he's on his own. He doesn't have transportation. He doesn't have any money. It's why he's been unable to test. I did not discuss a scram tether with him, but I don't think he would oppose that. He has not been using any substances or drinking alcohol. He was in court with us on that first violation for not going to report the test. So he certainly wants to prove to the court that he is following the bond conditions and not consuming drugs or alcohol. He just has been unable to afford testing. He does have an additional case in 54A that is still pending, and he's presumed innocent of that. His bond there is revoked until he sees the judge on April 9th. I would ask the court not revoke bond here, given that he'll be in custody until April 9th. And upon his release, if he is released out there, he could get his scram tether on and report to the probation department.
Okay. So given that, and there are, so this would be Mr. Chilumba's 6th and 7th sets of violation of bond since he's been before this court. So as Ms. Rensman said, we've just had no non-compliance, understanding the barriers that have been communicated here today. There still is just, non-compliance. And additionally, now, while we don't have that before the court officially and formally, there looks like there could be another show cause for the violating term of his bond that he shall not commit any crime while he is on bond. Absolutely presumed innocent, and he is still pending that case. But nonetheless, here we are today, and he is now has a bond in another case and is being remanded. What we need to do, Mr. Chilumba, at this point is we need to get your pre-sentence investigation report done. The best way to do that is for our probation department to conduct that interview while you are in custody, and you are going to be in custody in another court until at least April 9th. So I'm revoking your bond here today. I'm ordering that the probation department will conduct that pre-sentence investigation interview as soon as possible at the jail, and then we're going to get a date for sentencing. So with that, Ms. Horn, if we could look at the docket. I know, Ms. Rensman, you may not, if you have any information about when it looks like that interview could be done at the jail.
I would need to look at Officer Bragg's schedule. I
Okay.
don't mind doing that after we hop off here. I am sure that he can get him in timely.
Okay. And Ms. Horn is actually telling me, I think she communicated with Mr. Bragg, that interview is going to happen on April 1st, which is fantastic. And thank you to Mr. Bragg for that. And so if we have the PSI interview done on April 1st, just realistically, if we could set this for sentencing, I think we're going to do is set it for sentencing even before, if we could, before April 9th. And if Mr. Bragg is unable to accommodate that, we will reset it. But as of now, Ms. Horn, could we look at that week before April 9th? And just as we're looking for that, okay, so we'll be back together for sentencing on April 7th at 10 a.m. Thank you. And Ms. Vachon, do you and your client wish to waive his right to be present in person for that hearing? And we could do it via Polycom, or how would you like to proceed?
Michael, do you want to be brought in person for sentencing, or do you want to do it on video from the jail?
Uh, since I'm not going home today to be in the jail.
Video?
Yeah.
Okay,
Your Honor, we would
so
waive
we'll
in
note
person.
that. Thank you so much. So we'll have the Polycom set up for that, and note that Mr. Chilumba waived his right to be present. And if there is any issue with this date and being able to have the PSI prepared by that date, obviously the court will be in touch with the parties. But, we'll state for the record, and Ms. Rensman is here, and we can communicate this to Mr. Bragg, that just given Mr. Chilumba's performance on bond, there could be reason for the court to find that he would not be a good candidate for probation. And so perhaps, the PSI may be able to be pretty direct and to the point. So with all that, anything further on behalf of the city, Ms. Sumner?
No, thank you.
Okay, and anything from you, Ms. Vachon?
Oh, Your Honor, if I could just get a breakout room.
Absolutely. Ms. Rensman, do you have anything else on behalf of probation?
Nothing further.
Okay, and just to be clear for you, Mr. Chilumba, this court is holding you now too, but you're being held by this other jurisdiction in any event. Now that I've revoked your bond, sir, you get jail credit for all the time that you were going to be in jail anyway. So now every day between now and I see you, you'll be getting jail credit. And I know you and Ms. Vachon will talk about.
Here is an 18-year-old sitting in a jail cell, appearing on a video screen in a courtroom where he is supposed to be fighting for his freedom. And somehow, he is also simultaneously locked up in a completely different jurisdiction on a brand new felony charge involving a stolen motor vehicle. That is where this case stands before the judge has said a single word about sentencing. What unfolded in that courtroom tells a story that is equal parts frustrating and sobering. Bond violation after bond violation, 6 and 7 sets of them. Each one met with an excuse and another chance. No money, no transportation, no way to get to testing. And yet, when the probation officer stepped up to the microphone, the picture changed. The only 2 times this defendant actually did test, both came back positive for alcohol. And that is not a transportation problem. The judge recognized exactly that. To her credit, Judge Green never raised her voice. She did not lecture. She simply laid out the facts, acknowledged the barriers that had been offered, and then said plainly what the record demanded. Non-compliance is non-compliance. Bond revoked. And then, almost as a quiet warning shot towards sentencing, she noted on the record that this defendant's performance may mean he is not a good candidate for probation. That single line may end up mattering more than anything else said in that courtroom. Because what the judge was really saying is that the system gave this young man every opportunity it had, and he was unable to meet any of them. See, what happens at sentencing will tell us whether the court still sees a path forward or whether it has simply run out of road. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.